Good afternoon, everyone, and welcome to this third out of 3 sessions on employment for charities. We started off with a safer recruitment session. We moved on to managing the employment relationship, and today we're going to look at terminating employment. I'm joined today by my colleague Richard Hewitt, who's a partner in the employment team, and he's going to look at safer termination and some safeguarding considerations that you might want to consider around dismissal. And I'm going to take us through fair reasons for termination, fair procedures, protected conversations and settlement agreements, and then hand over to Richard. So if we start off by going to the next slide. Unfortunately, there are always circumstances where it might be necessary for a charity or any employer to consider bringing employment to an end. There are a number of reasons for this. It might be directly attributable to the employee's conduct, or it might be for a reason that's completely related to an external factor, such as a reduction in work, for example. And the impact of the pandemic is an obvious example of this. So before we look at the potentially fair reasons for dismissal, it makes sense for us to have a look at the statutory right not to be unfairly dismissed. So generally, employees who have 2 or more years continuous service acquire the right not to be unfairly dismissed. However, there are some circumstances where 2 years service isn't required, such as when someone's dismissed for blowing the whistle or for raising health and safety concerns. Only employees have the right to be unfairly dismissed, and therefore it's not a right that workers qualify for protection for. And in order to bring an unfair dismissal claim, an employee must have actually been dismissed. It sounds straightforward, but there are 3 circumstances in which a dismissal takes place. And so that's being expressly dismissed by their employer. Their fixed term employment comes to an end at the end of their contract, or they've been constructively dismissed. So this means when an employee resigns in response to a fundamental breach of their employment contract by their employer. So in an unfair dismissal case, the burden of proof is on the employer to demonstrate that they had a fair reason to dismiss the employee. So they must be able to evidence that they followed a fair procedure as well as having a fair reason. I'll explore both of these points in detail shortly, but before doing so, I just wanted to highlight the remedies that might be available to an employee who brings a successful unfair dismissal claim. So the following remedies are possible. A tribunal could order reinstatement. So this would mean that they're given their old job back and they're compensated for any losses that they've experienced since dismissal. They could be re-engaged, which is similar to reinstatement, but they're not provided with exactly the same job, but a similar job, and also receive compensation for any losses sustained. And then the more common outcome or remedy is compensation. So a successful claimant will be entitled to a basic award, which is calculated in the same way as a statutory redundancy payment, and it depends on length of service, age of the individual, and it's capped at £544 per week in terms of their gross pay, and the maximum basic award that an employee can receive is £16,320. So in addition to that basic award, an employee is entitled to a compensatory award as well. And this is calculated based on what financial loss they've experienced to the date of the tribunal, and also what financial losses they can expect to sustain until they find alternative employment. Obviously, they've got to take steps to try and find another job and to mitigate their losses, but they can receive up to a year's pay or £89,493, whichever is the lower of those 2 amounts. In some circumstances, unfair dismissal compensation can exceed that, for whistleblowing, for example, but for the majority of cases in straightforward unfair dismissals, the cap would apply. So if we move on now to the next slide and we look at those fair reasons for termination. So there are 5 potentially fair reasons. On the slide you'll see these are capability, conduct, redundancy, breach of statute, and some other substantial reason. If the charity's reason for dismissal doesn't fall within one of these categories, then the dismissal is likely to be found unfair by a tribunal, and the employee will be eligible for one of the remedies that I just went through. So if we look at each of the fair reasons now in a bit more detail. So if we go on to the next slide and look at capability. A dismissal is potentially fair if it relates to the capability or qualifications of an employee for performing the work of the kind that they're employed to do. So capability-based dismissals usually fall within two camps. You've got dismissals because of poor performance, and then you've got dismissals relating to ill health that prevent someone from performing their role. Dismissals for these potentially fair reasons would, in some circumstances, also trigger some responsibilities under the Equality Act. So looking at reasonable adjustments, for example. So if someone is prevented from working for ill health and that condition qualifies as a disability, the duty to make reasonable adjustments would be engaged. And so as an employer, you would need to think about what steps you could take to help alleviate any disadvantage that that individual has potentially experienced as a consequence of that disability. So whilst a dismissal might be fair in terms of the Employment Rights Act and unfair dismissal, if you don't go through that process of looking at reasonable adjustments and considering disability, it could be unlawful under the Equality Act. So something to consider. And then if we look at qualifications, in terms of qualifications, for the purposes of the Employment Rights Act, these are qualifications such as degree, diploma, or other academic, technical, or professional qualifications that are relevant to the employee's work. And so it could also include a graduate scheme or apprenticeship that the charity itself runs, so an internal qualification too. And if the individual hasn't achieved those qualifications or doesn't have the qualifications that they purported to have when they applied for the role, this could create a fair reason for termination. So qualification dismissals usually arise soon after recruitment if it emerges that someone hasn't got the qualifications they said they had, or if they're employed on the understanding that they'll obtain a certain qualification but fail to do so. And then there are other situations where the employer's requirements might change, and it might be reasonable to require an employee to obtain a certain qualification. And again, if they fail to do that, it might give grounds for a fair reason for termination. And then probably the most common qualification issue is where someone loses a qualification that's required for their job. So the most obvious one is a driving license. So if someone's employed in a role where they have to drive and they lose their driving license, they can't do their job, and so it would create a fair reason for termination. If we move on to the next slide, we'll look at conduct. So conduct's a potentially fair reason for dismissal. And if an individual's conduct falls short of the standards required of them, it may give grounds for termination. So this could be a single act of misconduct, or it could be a series of less serious incidents of conduct. So examples of misconduct could include things like disobeying a management instruction that's reasonable and issued to the employee. It could be acting in a way that breaches the employment contract. So doing something that's inconsistent with the duty of good faith or mutual trust and confidence. It might be theft or dishonesty, or unauthorized absence, or violence or intimidation in the workplace, using offensive language, or submitting a colleague to harassment, or other things like poor attendance or disclosure of confidential information. And so the main difference from a legal standpoint in terms of what is misconduct and gross misconduct really falls down to the severity of that conduct and whether it's a willful act of negligence on the part of the employee. And where you're looking at gross misconduct, this is conduct that is so serious that it would mean that the individual has fundamentally breached their employment contract and it entitles you to terminate their employment without notice. Whereas lesser misconduct would require termination on notice and might require prior warnings before dismissal is contemplated. So in terms of helping employees recognise what conduct's expected of them and what would constitute gross misconduct, it is helpful for a charity to have within its disciplinary and grievance policies, particularly within its disciplinary policies, clear examples of what kind of conduct would amount to gross misconduct, so that those standards are set, expectations are clear, and then if the employee then goes and breaches those standards, it's reasonable to take steps towards termination. So not only is conduct within the workplace counted for the purposes of dismissal, you can in certain circumstances count conduct outside of the workplace, and that's conduct that would have a significant impact on the reputation of the charity, or conduct that could be particularly damaging. So examples of that might be the harassment of a colleague outside of work, or being involved in some form of criminal activity that would render that person not suitable for the work that they do for the charity. We've seen an increase of misuse of social media, where employees might post something online that's inconsistent with the charity's values or would amount to harassment or something offensive to a colleague. And those could all give grounds for disciplinary action and could lead to termination. So if we move on to the next fair reason, we'll look at redundancy. So a dismissal on the grounds that an employee is redundant is a potentially fair reason. This applies where the dismissal is wholly or mainly attributable to the charity either ceasing or intending to cease to operate. So this is commonly known as a business closure. The charity ceasing or intending to cease carrying out operations in a particular place, so a workplace or site closure, or where the charity has a reduced requirement for employees carrying out a particular kind of work or a particular kind of work at a particular workplace. So this can often arise where the requirements of the charity evolve over time, and the nature of the work that employees are employed to do changes, and the needs and requirements of the charity require a different skill set, for example, and that skill set can only be delivered through making changes to the structure or changes to the way in which staffing resources are organised. Sometimes business reorganisations can fall within some other substantial reason, which is another fair reason for termination, which I'll come on to in a minute as well. So there is a crossover quite often between fair reasons, and it's for the employer to highlight which of those fair reasons, primary and also possibly in the alternative, they rely on for termination. So if we come on to the next slide, we'll look at breach of statute. This is often referred to as illegality as well. So it essentially means that it's a fair reason to dismiss an employee if continuing to employ them would mean that the charity is in breach of the law or a statutory requirement. So this comes about most commonly in immigration cases, where carrying on to employ someone who loses the status to work in this country would contravene immigration rules. It might also occur in regulated activity, for example, where someone is barred from working with children or vulnerable adults. And in those circumstances, the employer couldn't continue to employ them in that role. In practice, this is a fair reason that's fairly rarely relied on, but I just cover it for completeness. And then if we look at some other substantial reason, so this is a catch-all almost. It's in place so that it gives an opportunity where a fair reason exists but doesn't fall comfortably within one of the other categories for an employer to say that there is some other substantial reason of a kind that justifies dismissal of an employee holding that position. So it's called some other substantial reason. It's often referred to as SOSR as well. And the common situation to which it applies might be a personality conflict between a member of staff and another colleague, or between a member of staff and a whole team, where it's untenable for individuals to work together. It might, as I mentioned, reflect on a business reorganisation, and in those circumstances where a reorganisation takes place, it might be some other substantial reason for a fair dismissal. And the name gives it away. It has to be a substantial reason. It can't be trivial. It needs to be of sufficient severity to justify dismissal. And a tribunal would look at whether an employer has looked and exhausted other options before considering termination. So if we looked at a personality conflict, for example, has the employer tried mediation or redeployment or a change in line management before thinking about termination as a way forward? So if we move on to the next slide, please. And we look at reasonableness. So I'll just touch on reasonableness. Whilst a charity might be able to identify a fair reason for termination, it must also be able to demonstrate that it's reasonable to rely on that reason and to treat it as sufficient for dismissal. So when assessing reasonableness, a tribunal will look at whether other employers of the same size, with the same resources as the charity, would have treated that reason as sufficient for dismissal. And this is referred to as the band of reasonable responses test. A tribunal will also be mindful of factors such as whether a fair procedure has been followed by the charity, whether expectations for the employee around their conduct, performance, attendance at work, if it's a capability issue, have been made clear to them, and whether alternatives to termination or dismissal have been fully explored before termination is progressed. So if we move on now to procedural fairness, and this is really the second limb to the fairness of a dismissal. We've got a substantive fair reason, and then was a fair procedure applied? And interpreting the statutory requirements for reasonableness, tribunals have developed a requirement that in order to be seen as acting reasonably, an employer must have followed a fair procedure when dismissing an employee. So this will mean that the principles of fairness need to be applied in situations where a dismissal is based on conduct or performance. There's the ACAS Code of Practice, which sets out the requirements for a fair procedure, and it would, for lesser issues of misconduct, require warnings to be issued to the employee, would require investigation of the allegations against the employee, and to share information with the employee so they understand the allegations and can defend the allegations against them at a hearing. It would require the employee to be given a written outcome of the disciplinary process so that they can challenge it and appeal, and scope to appeal that decision too. The nature of a fair process will depend on the fair reason to be applied. So when you're looking at a redundancy situation, for example, you would be considering consultation requirements, notifying the employees who are at risk that they're at risk and the reasons why, considering fair selection pools, looking at objective criteria for applying to those selection pools to see who would be provisionally selected, ensuring that the right to be accompanied is applied. And in circumstances where you're looking at capability, a fair procedure would involve obtaining medical evidence, liaising with the employee to understand any restrictions that their condition places on them and their ability to undertake their work, looking at making adjustments if needed so that they can carry out their duties in a different way, thinking about things like redeployment before dismissal, and getting fresh and up-to-date medical evidence as the process continues. So all of these things help to form a fair process, and without doing that, a substantively fair reason might fall away in terms of an unfair dismissal claim because the charity hasn't acted reasonably in the way in which it has progressed the dismissal. And so in circumstances where an ACAS code applies, so the disciplinary code, for example, it has an impact on compensation as well. So not only does it impact the fairness of the dismissal, it actually would or could potentially create an uplift in any award. So also something to be mindful of. And whilst you're not required to follow the guidance, the impact of not following it could be a financial uplift. Therefore, it's important that it is followed. So if we move on now to look at protected conversations and settlement agreements. So as an alternative to going through a process with an individual or using one of those fair reasons to terminate, many employers have protected conversations and have discussions with their employees with a view to achieving an exit under a settlement agreement. And there's two main ways in which you can have those conversations so that they wouldn't be admissible in proceedings. And one way is to have that on a without prejudice basis, and that would apply where there's already a dispute in place. The alternative is to have a protected conversation, which would mean that matters discussed in that conversation wouldn't be admissible in unfair dismissal proceedings. The limitation of protected conversations is that they don't apply to other types of employment tribunal claims, so discrimination claims, for example. So an individual could rely on what was said in that discussion as evidence in a discrimination claim if they felt, for example, that it was being offered to them in a way that was discriminatory or indicated that their employer had discriminatory intent to remove them from the workplace based on a protected characteristic. So if we think about the protected conversation, there is ACAS guidance on the steps that employers should follow when they're having a protected conversation. This was put in place to prevent employers from potentially abusing the protected conversation regime and putting undue pressure and influence on employees to accept a settlement agreement with really short timeframes and threats that the deal will be off the table if they don't accept it by morning. So the essential parts of the code are that the offer can be in writing and that the individual has 10 days to consider it. And this gives them time then to get legal advice, think about the settlement agreement terms that have been proposed, and to feel that they're not under pressure and making a decision under any kind of duress. If we move on to the next slide, please. So the final thing that I wanted to talk about is charity commission considerations when entering into a settlement agreement. So there has been much press about gagging clauses, sometimes known as NDAs, sometimes referred to as confidentiality clauses, and how over time they've potentially been misused by employers to hide or conceal wrongdoing. Within the charity context, there's been a lot of publicity around bullying culture and settlement agreements being used to minimise that, and to gag those who have raised concerns or have blown the whistle on whistleblowing, blown the whistle on bullying, from speaking more widely about it. And so there is a move to move away from that and to give individuals who sign up to a settlement agreement the ability to be able to raise concerns, so blow the whistle, or to report criminal activity, or to take part in proceedings without breaching the terms of the settlement agreement that they've reached with their employer. And so in terms of good drafting now, you would expect a settlement agreement to have carve-outs that allow for an employee to do that. So certainly they have to be given the opportunity to be able to blow the whistle if they have concerns, and they can't be restricted from doing that, and to be able to report concerns to regulators, to be able to take part in litigation if they're called as a witness, and to not be restricted on what they say during that litigation, and to report matters to the police, or to assist with police inquiries if there is a potential criminal issue. And then the final thing I wanted to talk about is settlement payments and the regime on which charities operate. So if a charity is thinking of making a termination payment to an employee and that payment exceeds their statutory or contractual entitlements, so redundancy payment, notice payment, if you're looking to pay something on top of that as a termination payment, there are potential restrictions to think about. As a charity, any payment has to be in the best interest of the charity, has to be in furtherance of your charitable objects. And so making an ex gratia payment, for example, wouldn't necessarily be in the interests of the beneficiaries, because it's something purely for the benefit of the employee who isn't a beneficiary. And in those circumstances, those kind of payments would need scrutiny and would need prior approval by the Charity Commission. If, as a charity, you can justify that the payment that you're proposing to make is in the best interest of the charity, if it's settling a perceived risk of litigation, or if a claim has been threatened, then a payment, providing that is at a reasonable level and is proportionate to that risk, could be justifiable. Similarly, if you could show that making that payment helps preserve the reputation of the charity, if it would save costs in terms of legal fees for defending a claim, or would assist the charity in making operational changes in a way that limits the cost that you'd have to spend in, say, going through a redundancy process, or allows you to make changes quickly that are going to really benefit the charity, then these are all reasons that you could use to present an argument as to why a payment above contractual and statutory amounts are being paid. And so it's important to record that justification as you go through that process, so that if it's ever scrutinised later on, you can show that the trustees of the charity went through the decision-making guidance that's in place by the Commission, and that the payments were thoroughly scrutinised and were justified on the basis that I just went through. And so keeping that record at the time that the decision was made is really important, and something that charities should be doing as good practice when entering into any settlement agreement where they're paying more than the statutory or contractual requirements. So that brings me to the end of the things that I wanted to talk about. I'm going to pass you over to Richard now, who will take you through some safeguarding considerations on termination.
Okay, thanks, Jo. Yes, I'm going to have a brief look at how safeguarding matters can affect the process of terminating employment. I mean, sadly, it's something we advise on fairly frequently. To start with, and as we've mentioned in previous seminars in this series, the safeguarding doesn't just apply to charities who work with children or with vulnerable adults, but it applies more widely because of the charity safeguarding duty, which is set out in the Charity Commission guidance, safeguarding and protecting people for charities and trustees. And this states that all charities must take reasonable steps to protect from harm everyone who comes into contact with a charity. So we can see from this that this duty, as we mentioned before, is not limited to children or adults at risk. And that's one of the key points. Another key point is that you're required to take reasonable steps to protect people from harm. We've covered this before in the context of safer recruitment. In the context of sort of dealing with safeguarding allegations and terminating employment, well, the Charity Commission will expect all charities to be able to handle these matters in a reasonable way. And as part of that, they say the charities must know how to spot and handle concerns in a full and open manner. Now, Joe mentioned earlier about having disciplinary rules within disciplinary examples of misconduct and gross misconduct within your procedures. Those sorts of documents all help a charity to know how to spot and handle concerns in a full and open manner, as does having a comprehensive code of conduct, which covers off issues like harm and safeguarding, and it will help staff to identify behaviours that are concerning, because it's an opportunity for you to set out examples of what behaviour is expected and what behaviour is not tolerated. Charity Commission also expects a charity to follow statutory guidance, good practice guidance, and any other legislation relevant to their charity. So again, it's a case of being aware of any guidance that applies within your sector, following it, making sure it's reflected in your policies, but also in your day-to-day practice. The charity is quick to respond to concerns and then to carry out appropriate investigations. So again, having disciplinary procedures, disciplinary rules, and even capability procedures that are applicable to safeguarding concerns is really important. And finally, that the charity doesn't ignore harm or downplay failures. So again, that's saying that safeguarding matters need to be dealt with openly, fully, and transparently. And I think the worst position to be in here is being accused of not dealing with a safeguarding matter during employment sufficiently seriously, or being accused of trying to sweep something under the carpet. Can I have the next slide, please? So just moving on to look at some of the sort of initial considerations when we talk about safeguarding and termination of employment. So there are additional considerations that always apply when we have a safeguarding matter come up. The first is to identify whether it is a safeguarding matter, whether there has been harm, and to whom. I'll just set out on this slide and the next just some legal definitions of harm. I appreciate they may not be directly relevant to your charity, but it gives you an idea of what you should be thinking about. And also, harm is a term that's mentioned in lots of documentation, lots of guidance, but it's rarely defined. So I've always found these definitions quite helpful when working with charities. So firstly, there's a definition of the Children Act, which talks about harm being ill treatment or the impairment of health or development. That health means physical or mental health, and that ill treatment includes sexual abuse and forms of ill treatment which are not physical. So we can see again, it's a broad spectrum. Harm is defined quite broadly within the Children Act. If we have the next slide, please. And sort of more, there's an even broader definition within the explanatory note to the Safeguarding Vulnerable Groups Act 2006, which has some pretty broad application itself. And this definition states that the term harm is used in relation to the thresholds for barring and for the duties to refer information to this disclosure and barring service. And it goes on to say that the term is purposely not defined in the legislation because it's intended that it should take its normal everyday meaning. And that, in my opinion, makes the threshold for determining whether something amounts to harm quite low. If you think a behaviour, a culture, or a process that has harmed or hurt a person, then there probably has been harm. And I would say it's better to be cautious when we're dealing with these sorts of matters, because the consequences of not dealing with harmful behaviours can be extremely damaging to the people involved, but also to the charity itself and to its reputation. I think when we are looking at harm, and it's perhaps sometimes easier to identify this where you are dealing with children or you're dealing with adults at risk. But I think we should also think about it in a broader context as well. Other types of behaviours that commonly arise in the workplace, or could involve others who come into contact with a charity. And I've set out a list there, and that list is defined by the Charity Commission as among those safeguarding risks that a charity needs to be aware of and to deal with. So this involves sexual harassment, abuse and exploitation, physical or emotional abuse, but with a broader concepts such as bullying and harassment, discrimination on any ground in the Equality Act, and general cultures which allow poor behaviour and poor accountability. These sorts of things all arise in the workplace. I think we can sort of more confidently say now that the harm can arise from all of those behaviours. We've got movements such as Me Too and Black Lives Matter. Everyone's invited. They've all highlighted the harm that can result from abuse and discrimination, harassment and bullying. And I would advise all charities who don't necessarily work with children or adults to think about harm in this broader context as well. I could have the next slide, please. So in terms of a sort of process and dealing with these matters, as I said, you've got the additional consideration of working out, is it a safeguarding matter, is there harm in the first place? And then once you've taken that decision, what are the next steps? And firstly, do you need to be following a fair process? I would say, of course, you do. It applies equally in safeguarding matters, and that's even where you're faced with perhaps very serious misconduct. We've often had employers say, well, do we need to carry out a process here? Can we just not terminate employment? That the conduct in this matter is so serious that surely we can just move straight to termination. But it's still the case that a fair process needs to be followed before a termination can be effected. So the process is key. These are usually disciplinary matters, but they could in theory be capability matters if harm arises in the context of someone's poor performance as well. So keep an open mind, but they commonly end up being disciplinary matters because it's related to conduct. One of the initial considerations for every charity is are there any external bodies that you would need to report to before that you can deal with the matter internally? So for those charities who work with children or vulnerable adults, and there will be duties to report matters involving harm to children or vulnerable adults to the local authority. And what's the purpose of that? Well, firstly, it's transparency. And historically, many matters have been dealt with in-house, and this has allowed unsuitable people to be recycled in the particular sector in which they're working, which is something we should all strive to avoid. Secondly, it's about guidance. You can get helpful guidance from trained third parties within local authorities, and therefore making these referrals at an early stage in the process is really important and helpful for you as a charity. And then it might be that making referrals leads to the involvement of other third parties, such as the police, and making sure that none of those sort of duties and obligations are missed out. That's not applicable to you if your charity doesn't work with children or vulnerable adults. But if you do, it's important to remember that this is the first step before you go and carry out any investigation yourself. And the reason for that as well is that you don't take any steps at an early stage that might then go on to compromise an investigation carried out by a third party at a later stage. What if the police get involved and there's a police investigation to deal with a safeguarding matter? Well, firstly, if that's the case, then it's likely that will prevent you from taking any steps to carry out an internal investigation whilst that external investigation is ongoing. It's also likely to result in significant delay to your processes, during which period the employee is going to still be employed and is going to be in receipt of pay. So it can be expensive if safeguarding becomes involved in these matters. And it's usually a case that you will have to wait until the conclusion of an external investigation. And as I mentioned earlier, to do otherwise, it can risk compromising these investigations. And if that was to result in the collapse of a police investigation or even a criminal trial, then you can imagine that the charity would suffer some quite severe criticism for any role it played in that. It's always important if the police or any third parties involved to keep in contact with them during their process to see what information you get from them that might be something you can use during your process. It's also really important, I think, to get written confirmation from those third parties about when they are happy for you to commence an internal investigation, and that they are happy for you to do so. I've also mentioned here is an obligation to follow a process through to its conclusion, and this often arises where we've got safeguarding matters involving employees who have less than 2 years service, and you may therefore think, well, what's the point in us following this process when we can bring employment to an end here with little risk of an unfair dismissal claim? Well, again, I think just to check what framework applies to you. So, for example, schools are specifically required under Keeping Children Safe in Education to see these matters through to a conclusion, even where an employee has less than 2 years service, or even where an employee resigns prior to any disciplinary hearing taking place. What's the reason for that? I mean, it's accountability, it's gathering information, it's information sharing, again, to prevent unsuitable people from being recycled. Again, this wouldn't apply to all charities, but what I would say is remember the charity safeguarding duty that I mentioned earlier. If you're not following these processes through, are you dealing with them in a full and open manner, as the Charity Commission expects charities to do, and are you ignoring or downplaying harm or downplaying failure as well? And what I would say is, if these matters can result in further investigation, if serious harm results from a person's behaviour, if you were ever asked to explain what you had done, would you be able to confidently state that the process you had followed had been thorough and fair and reasonable in the circumstances? Because really, that's the position that you would want to be in. Moving on to settlement agreements, Joe, of course, mentioned the use of settlement agreements. I just wanted to cover whether they can be used in safeguarding matters and whether they should be. I think the basic rule is, ideally, you should avoid the use of settlement agreements in safeguarding matters. They do get used. If they ever get used, then it should always be with the caveat that they won't prevent the charity from disclosing information as it's required to do. So, for example, in a reference or in post-termination referrals. I also caution against the use of them from a reputational perspective. Do you really want to enter into a settlement agreement with a person whose behaviour may have been harmful? So they can be used. They need to be used carefully, both from a legal perspective and a reputational perspective. And then moving on to look at references in safeguarding matters. Now, if you've terminated employment for a safeguarding reason, what do you have to mention in a reference? Well, it depends on your policy. There's no blanket requirement to provide a reference or to provide a detailed reference. And of course, many employers will provide only a dates-only reference or a dates-only with a job title and no more information, which of course reduces liability, but it's not particularly helpful from a safeguarding perspective or an information sharing perspective. I would say that if you have dealt with a safeguarding matter formally and internally with the individual and it's resulted in termination or a disciplinary sanction, and you then don't mention that matter in a reference you provide, you could be leaving yourself open to criticism from the recipient of that reference, and perhaps even a claim for negligent misstatement. So, as a general rule, if you deal with safeguarding matters and you deal with them properly and in accordance with your policies, then my advice would be to include mention of them in the references you provide. Moving on to what should be mentioned, again, whether there's an external legal framework or guidance that's applicable is something you should check. So, for example, in the education sector, Keeping Children Safe in Education states that schools must mention substantiated safeguarding references, safeguarding allegations in the references they provide. And again, looking at the charity safeguarding duty, which is more generally applicable, well, passing on information regarding matters you have dealt with will make it harder for unsuitable people to carry out work in the charity sector. And I think that's something that should be looking to achieve. Not passing on that information could also leave you open to criticism if you don't pass that information on. What I would caution against, however, is passing on information in a reference relating to a safeguarding matter if it's not been properly dealt with and the individual is unaware of it, because that could leave you open to claims from the subject of the reference. And then what about agreed references? Is it possible to agree those? following the conclusion of a safeguarding matter? Well, again, I would say it's best to avoid using agreed references, but again, they do get used from time to time. But only, we would say, if they mention the safeguarding concerns that have been dealt with. When using settlement agreements and agreeing a reference, often employers who work with children or vulnerable adults may agree to provide two references, one which mentions the circumstances of safeguarding complaints that have been dealt with, to be provided to a prospective employer where the work is with children or vulnerable adults, and a second reference, which perhaps is a dates-only reference, which is to be provided to employers in other sectors. If you do take that approach, then generally it is acceptable. But what I would caution you against is just making sure that any agreed references are provided directly to the prospective employer and not given to the employee to use. Could I have the next slide, please? I just want to finish by just mentioning reporting obligations that arise out of safeguarding matters. So there may well be, so this sort of talking post-termination now, you've dealt with the matter, you've terminated employment, there are still these additional considerations to take into account. Why would that be? Well, it's so relevant that parties can decide whether it's appropriate to impose further sanctions or restrictions on a person's ability to carry out work in a particular sector. So there are specific sector obligations that may arise to report a person to a regulatory body. So the Teaching Regulation Agency is a common one, where schools are required to make referrals in circumstances where there has been a dismissal for unacceptable professional conduct, and safeguarding matters nearly always result in a report being made. There's also an obligation to make referrals to the Disclosure and Barring Service. The Safeguarding Vulnerable Groups Act requires regulated activity providers to make a referral to the DVS if an individual is removed, so dismissed, or removes themselves, so resigns from regulated activity, because they have either engaged in relevant conduct, satisfied the harm test, or been charged or convicted of a relevant offence. So really what we're saying is their employment within a regulated role has come to an end broadly because of harmful behaviour on their part. And again, I'd urge caution here as well in terms of whether if you're agonising on either whether to make a referral, because it's a criminal offence not to refer when the duty arises. And our advice would generally be, if you're in doubt, make a referral and let the DVS decide on whether any further action is necessary. And can I move to the next slide, please? Just finally, just to look at making a serious incident report to the Charity Commission. Firstly, there is Charity Commission guidance on this called How to Report a Serious Incident in Your Charity, which I'd recommend you do familiarise yourself with. What is a serious incident report? A serious incident in first case? Well, it's the Charity Commission decided that describe this as an adverse event, whether actual or alleged, which results in or risks significant harm to the people who come into contact with your charity, loss of your charity's money or assets, damage to your charity's reputation, or harm to your charity's work or reputation. And when they talk about what's significant, it's significant in the context of your charity, taking account of its staff, operations, finances, and its reputation as well. And this guidance goes on to give examples of what should be or what are commonly reported. And they talk about beneficiaries or individuals connected to the charity suffering serious harm. A widespread culture of bullying within a charity would be something that's considered reportable. Or, and this is quite broad, any other type of incident that appears serious and likely to damage reputation. So, bringing it back to safeguarding matters, they're often reportable, especially where the police is involved, especially where there's media coverage, or there's the prospect of, or where there will be a criminal trial as well, because they will all become matters that make their way into the public domain, and therefore they're likely to be damage to reputation and potentially to beneficiaries as well. Whose decision is it to make a serious incident report? That falls to the trustees. And in terms of timing, when do these reports need to be made? Well, again, the Charity Commission guidance says as soon as reasonably possible. They describe it as promptly. So as soon as reasonably possible after it happens, or immediately after your charity becomes aware of it. And what I would say with this is much better to be in control of this reporting process than for a serious incident to come to the knowledge of the Charity Commission through a third party, or even worse, through the media. I will hand back to. I've come to the end of that section there, but just some things for you to consider in addition to the employment law fundamentals.
Thanks, Richard. I've been keeping an eye on the Q&A box, and I don't think we've got any questions in. But if anyone has any questions after you've had a time to reflect on what we've talked about today, please do email us. We'll be happy to look into them and happy to respond to you directly.